Member for Opuch East, you have 6 minutes and 8 seconds of original time left.
Thank you very much, Madam Speaker. Madam Speaker, returning to the non-profit organization bill and the inherent danger that this bill poses to the voluntary sector, the NGO community, and the non-profit organizations in this country, I just wanted to call on the Attorney General to, it may be in the best interest of the objective of the bill to either withdraw the bill in its entirety or subject this bill to some type of consultation in the national community and with members of the opposition, not only in the Parliament, but elsewhere. Madam Speaker, it also came to my attention that the NGO community, and particularly, I think, the network of social organizations, indicated that they had no sight of the bill. They had no sight of this piece of legislation, and they were also caught unaware that this bill was before the Parliament. Now, that is a very significant and huge community of NGOs in the country, so that even if the Attorney General believes that for 3 years he has been fighting and consulting, clearly he has not been consulting the organizations themselves that are being affected. Madam Speaker, the issue is really the wide breadth in terms of definition of this person called the controller. And I just want to read it here into the record from the page 2 of the bill. Controller means a person who has the control or management of the non-profit organization and includes a director of a non-profit company, a trustee of a trust, a person responsible for the management or administration of an unincorporated body, a senior officer of the non-profit organization, or a person not specified in paragraphs A to D, where the non-profit organization is owned, controlled, or managed by that person. Madam Speaker, this is much too wide and require simplification, Madam Speaker. Madam Speaker, there's also, when you look at clause 14, I want to touch on that now. A controller of a non-profit organization shall ensure the proper financial accounts and records are kept. Now, it doesn't speak here specifically to whether this non-profit organization is in the category that the Attorney General deems to be $10 million plus in income per year. This speaks generally, so one has to assume with a literal interpretation that a controller of a non-profit organization is a controller of any non-profit organization. And here, they must keep records, all sums of cash received and expended, and the matters in respect the receipt and expenditure relate. All gifts, sales, and purchases of property, all sums of cash raised through fundraising, or non-monetary transaction as may be prescribed by regulations, all assets and liabilities, and any other matter that may be prescribed by regulations. Madam Speaker, many of us have many years of experience in the real world. Many of these non-profit organizations, particularly smaller ones, they keep their filing system in the trunk of a car. In the back seat of the car, they get letter, they throw it there. When they're ready for it 2 months later at a meeting, they can try to find it. There's really no filing system like that. And to now impose some legal obligation to keep all these records and fundraising and so on. I mean, my friend from San Fernando East, I thought he tried to start up earlier, but if you had spent, more time in the gym, you would have stood faster. But we are in the same gym, Madam Speaker, so I can tell him that. I don't see him often, but we're there. Madam Speaker, my friend from San Fernando East had, I believe, a wonderful carnival function a couple of years before. I believe it was the Friends of San Fernando East. He would have raised some funds and so on, and he would be a controller. He has to keep records of all this, the cash raised through fundraising, assets, liabilities, what was done with that. Madam Speaker, a controller of a non-profit organization shall ensure that the financial accounts and records show and detail all transactions of non-profit organizations and disclose at any time with accuracy its financial positions. The Minister of Social Development will tell you, and I think another ministry, Community Development, will tell you, Madam Speaker, that in the real world, they write organizations for, for their accounts and their statements and so on. Not audit, just for statements. And it would take them years before an organization will satisfy their requirement. You're asking these organizations to satisfy the Registrar General in law. Today, the Minister of Finance read a report, had to do the reading for reports. Do you know there's a report that Parliament received today of the National Carnival Commission for 2005? For 2005, the minister slipped almost. He couldn't believe it when he was reading it. So the National Carnival Commission gave us audited report in 2019 for 2005, and you are asking the little non-profit organization, get all your records up to date, sales, purchase, assets, liabilities, accounts, records with accuracy. This is a madcap plan. You have a few months transition period, of course, yes. And Madam Speaker, this piece of legislation will affect all organizations. The Attorney General needs to quickly restrict this to the organizations that he has an intention to deal with.
Number 4, Puchis, your original time is now expired. You have 15 more minutes to complete your presentation. You may proceed.
Madam Speaker, I thank you so much. To the Attorney General, I will give you an example in your own constituency. I think it's the 3rd Street Mandira in San Fernando. There's a vibrant women's group that raise funds and have tea parties or what have you to raise funds and so on. They are a non-profit organization by themselves that is very dynamic in San Fernando West. And your own constituents may have a word or two with you on this matter and the stringent and oppressive requirements that the law will now impose on organizations like that. And clearly, Madam Speaker, I mean, the member for San Fernando West, as I believe a frequent visitor to that place of worship, will know that they are not raising funds for nuclear weapons in the Far East. They have never been accused of being involved with financing any terrorist organization. And not only in that temple, there are churches, there are mosques throughout the communities that raise funds, small amount of funds for hosts of charity, because this country is at a stage where you just cannot depend on the government to get your assistance. So when you remove 50,000 food cards from people, people will need help. When you remove gate, people will need help. When you remove certain medical facilities and so on, people will need help, Madam Speaker. And it is the voluntary sector that will do that. Madam Speaker, the role of the Registrar General is also a concern for us, Madam Speaker, because the Registrar General has now a sort of enhanced role. And I'm looking at clause 6, power to grant or renew registration. Madam Speaker, the Registrar General is taking on now a very activist role in this matter. The Registrar General is satisfied that an applicant has met the requirements of this Act for registration or renewal of registration. He shall. So it is both registration and renewal. Approve the registration of the applicant in 30 business days. Now that is a very short time. 30 business days would be, a month and something. That's a short time in a place like this where things take time. One person at that office needs to be sick for a week, and you're getting nothing in 30 days. Issue to the non-profit organization a certificate of non-profit organization registration, the forms provided. Madam Speaker, a person named as a controller can be disqualified. The name of the non-profit organization and the circumstances for disqualification. The Registrar General may refuse to register or renew an application as a non-profit organization if, according to the following. But here it is. The name of the non-profit organization is the same or similar to a name of a registered non-profit organization, any other person, association, partnership, firm, any registered trademark, any well-known trademark. You see the research that is required here? I'm just asking whether this could be done in 30 days, that you do a check, all of those checks to ensure that the name is not, the name is not, when you have 8,000 organizations you may be dealing with at one time or another. Madam Speaker, where you can be refused registration or renewal, Madam Speaker, where is primarily a geographic name used alone unless the applicant establishes to the satisfaction of the Registrar General that the name has true use, acquired, and continues to have a secondary meaning. Now, you could explain that. I'm sure the Attorney General could explain or give an example of that. Because you see, Madam Speaker, there's an organization that I know of near me called the Debe Daredevils, and I think they are mirrored after the Delhi Daredevils. Now, they have organizations like this all over the place calling themselves Transformers and calling themselves like all type of names, which if you properly check them, could be the name of some major global institution of some kind or some major patented item that is used in another country. Now, these things operate and you take it as you get it. But now you are putting in law that they are not that they cannot be registered or renewed as a registration if you find out that the name in Arima or Point Fortin is the same name being used in New York by somebody for something else. You can do that. You can also be refused on another ground, which is interesting. If, Madam Speaker, you suggest or imply a connection with the state or the government or any ministry, department, branch, bureau, service, activity of government, unless consent in writing to a proposed name is duly obtained from the appropriate minister. Now, just again for clarification, we have all these organizations called the police youth clubs. What they now require for the bureaucracy to be satisfied that the minister with responsibility for the police would give an authorization, would give consent that they can use that term because the police is a department of state, so to speak. So that's another issue that you have to look at. Now, I only use police because it is so obvious, but there may be others that operate in the domain as well. But the minister, there's a provision here, unless consent in writing to the proposed name is duly obtained from the appropriate minister. So a minister now has a power to consent to a name to be used for registration and renewal of registration. Now, something is not too right with this, because that can open the way for nepotism, cronyism. It could open the way for helping family, for putting your family into positions, Madam Speaker, and giving them that right in law now that you can carry on a non-profit organization that is linked directly to your ministry by name, by association. And when they do that, you see this has implications. When you carry names of ministry to the public out there that may not be informed and aware, you brand yourself almost as the ministry. So you raise funds and people look at you and say, oh, this is part of the Ministry of the Attorney General. Oh, this is part of the Ministry of Social Development, because you have some type of link by name, which a minister can now give consent to. So when minister change, a new minister can come on the scene and say, look, I am in touch with a foreign organization. They want to sponsor my constituency. We can call it an arm of the ministry. And you set up a real problem that you never want to set up. So, Madam Speaker, I note that. The other thing I note is that what would be at number 6? You can be refused if it's a name in the opinion of the Registrar General for any reason. The name is objectionable. Now, what is that? What really is that? You should delete that immediately without talking. You cannot say in law that the Registrar General has this power for any reason to decide that that name is objectionable. On what grounds? What does the name offend someone? There must be specified grounds that it infringes some equal opportunity right. You know, in the equal opportunity legislation and makeup, they have certain things that link to this thing that you cannot use, language, slogans, and that type of thing. So, Madam Speaker, I plea with the Attorney General to look at that. Madam Speaker, the information that is required on the controller and on the organization is captured in 9 as the establishment of a register of non-profit organizations. Madam Speaker, you provide all the name. But you also need to update the Registrar General on any changes associated with that non-profit organization. Again, that will have a lot of bureaucracy. Persons will find themselves afoul of the law where an organization will move. As chairman or president of the group change, the address will change to the person's house. So there'll be a new house because the president changed. And a new house number. They have to go to the Registrar General, inform them, but if they don't, they commit an offense. Now, the effect of this kind of legislation, Madam Speaker, is that the persons who operate in this charitable voluntary sector, they will not offer themselves now for community purposes. Because they believe if they innocently or otherwise, but if they innocently forget to drop a document, did not keep this record or that record, they face jail. So you can be the leader of an organization raising money for kids playing cricket, football, athletics, lawn tennis, basketball, and you run afoul of this legislation and you go to jail. That is not what the spirit of community development and voluntary work is about. Clearly, you must have a mechanism now to regulate and give oversight so people do not, because I mean, part of our culture too is many of us in your constituency would know the voluntary movement will have a few people who are, serial tricksters. And, they come around at Christmas generally, many, but other occasions too, mind you. And and if you have been around for a little time in the constituency, you will know the tricksters, the fraudsters, the hoaxsters, and so on. And when they come, you meet and treat appropriately. But you cannot take this kind of legislation to trap all the innocent people who give up their time, Madam Speaker. There are many recipients of national awards in this country over the last 50 years who themselves, they earn their name, their reputation by their selfless service without any money at all to community and charitable work. Madam Speaker, we talk about the temple in San Fernando. You have the Syrian Lebanese Association. You have the Islamic Women. Madam Speaker, you have a lot of groups that raise money on an ongoing basis. I can call many. Have they been consulted? Have you spoken to them to indicate that if you become chairman or treasurer or, as a colleague told me earlier, the bookkeeper of the organization, you are a controller? If you sign the checkbook that goes out to pay some education or to build a center somewhere or contribute to cancer research somewhere, you are the controller. You could face jail. And Madam Speaker, my time is coming to an end, but I want to end by raising this very serious question. Is it that the government is using this as well, given the definition of non-profit organizations, Madam Speaker, to also look at political parties? There's a political party, I will not call their name, but they are raising funds to build a new headquarters. And they are raffling cars. They sell 5 tickets, give out 10 cars. And they're raffling, they're raising money. But it is money for a charitable purpose. So this is, Madam Speaker, a charitable contribution to build a house or build a headquarters to the party. That organization, is it covered here? And is this campaign finance reform through the back door? Are you bringing campaign reform through the back door by taking political organizations, trapping them here with raising money for charitable work, and then you decide, well, you will now audit. You will now have a way to audit, to dig up in their business, to search this, to search that, so you can find out who are financiers, who are donors, who are contributing to a political party, who is contributing to a particular candidate, using this mechanism. And that is a danger. These things, they come back to bite you. And I always tell my colleagues opposite, the only thing you are sure in life, well, you're sure of 2 things, but the only thing apart from death you are sure of is that one day all of you will be former ministers of government. You are sure of that. And I don't want to be too morbid, Madam Speaker, but I whispered to a colleague earlier during our recitals of condolences, I whispered to a colleague that all of us will have that one day. And it is what they will say about you would be the issue. And what they must say about you is that the years you spent here, you contributed to democracy, to transparency, to equality of opportunity. That was your fight. And then you would have a good talk. I hope they don't talk about you when you're alive that way. So, Madam Speaker, these are some of the major concerns, the regulations issue we raised earlier. I just also want to remind the Attorney General, I wasn't sure if he was in the House at the time, but with the regulations are very instructive. They say the Minister for responsible for legal affairs make regulations in relation to the RG. Those are negative resolution of Parliament. Those are, notwithstanding at number 426.4, you can also put penalties, including jail and fines and regulations, and this is untenable. We made the point. The Minister of Finance may make regulations in relation to the regulator in order to carry out the provisions of the Act. The Registrar General may, with the approval of the Minister, in this case the Attorney General, make rules prescribing forms, fees, and other matters relating to the registration of non-profit organizations. So you know what is happening here? Effectively, the Attorney General is determining fees.
As he does right now.
As he, well, not in this case now. No, the Attorney General may be doing it in other spheres of activity, which is good. But we are dealing with this particular one today. Whether or not a politician should be involved in determining fees for non-profit organizations in this way. Madam Speaker, I thank you.
Member for San Fernando.
Madam Speaker, I want to thank you for recognizing me. I did try on the last occasion, Madam Speaker, to catch your eye. But the member for Oropouche East jumped the gun and disrupted the order of speaking. After I told him, Madam Speaker, that I intended to speak after Saparia, and I don't know whether to feel flattered, because I really came to debunk a lot of the things that the member for Saparia had said. But now I have the opportunity to debunk a number of things that the member for Oropouche East has said. Madam Speaker, I want to thank you again for the opportunity to contribute to this Non-Profit Organization Bill 2019. And let me start off with the major point, Madam Speaker. The member for Oropouche East joined with his political leader, the member for Saparia, in saying that we're breaking the law. We're breaking the law, and that this bill interferes with property rights and violation of property rights. And Madam Speaker, I wonder if in the member for Oropouche East haste, that he simply did not understand the bill that was before him. And on a last occasion, Madam Speaker, I reminded the member for Oropouche East that I sat in a class with him. The class was called the Principles of Trust.
Oh, Lord.
We sat in the same class, and I reminded him of that. And it seemed as though everything went over his head. Because, Mr. Deputy Speaker, as I welcome you to the chair, Mr. Deputy Speaker, this type of organization is based on trust principles. And it's unlike a members club or a propriety club, Mr. Deputy Speaker. The property that is held by either the trustees in a non-profit organization or by the non-profit company itself are based on trust principles given to the trust company or to the non-profit organizations for what we call in law a purpose trust. And where you surrender the registration of a non-profit company or a non-profit organization, it means then that the trust fails. The property does not belong to the members. It is unlike a club or it's unlike a members club, Mr. Deputy Speaker. And that is why there are provisions in the bill to deal with the property on the failure of the purpose trust. It is as simple as that, on forfeiture or on a voluntary surrender. And I'll return to that, Mr. Deputy Speaker. Mr. Deputy Speaker, the member for Saparia also spoke about the fishermen and friends of the seas, and says that according to them, the law is a tool for abuse. But I would say to that, Mr. Deputy Speaker, that the fishermen and friends of the sea, the public really does not know who is behind that. And it is my impression that Fishermen and Friends of the Sea is a one-man band. And, Mr. Deputy Speaker, what this bill would do would be to disclose all the members of that non-profit organization. And what that would be down to, Mr. Deputy Speaker, is that it would create confidence and integrity in the non-profit sector. Yeah. And that's what it would do.
Another one-man band.
Mr. Deputy Speaker, the member for Siparia also indicated that we were not treating with for-profit companies, but the member for Siparia is really here, and she may have missed last week that we passed a bill in furtherance of dealing with these 40 recommendations from the Financial Action Task Force that deals with transparency and beneficial ownership, mandating the disclosure of beneficial ownership of companies. So we are treating with for-profit companies as well.
Treated with it.
The member for Siparia also went at length at clause 6.2 in saying that the controller would be disqualified if found guilty of a criminal offense of a term of imprisonment. But, Mr. Deputy Speaker, what the member for Siparia clearly missed is that the clause says may. May disqualify a controller. So therefore, the registrar has a discretion. And in an organization like Vision for a Mission, whose purpose is to rehabilitate offenders, Madam Speaker, I am certain that the Registrar General would apply that discretion appropriately. And in any event, Mr. Deputy Speaker, Vision and a Mission has many persons who can be deemed as controllers.
Correct.
Mr. Deputy Speaker, the member for Oropuch East also raised a point that the Kucharan Trace Police Youth Club could be found to be breaking the law. And I'd say to the member for Oropuch East, through you, that it may very well not be the Kucharan Trace Police Youth Club who may be breaking the law, intend to break the law, you know. It may be the actors or members who may, unknowing to other members in that police youth club, who may very well intend to break the law. And that is what this piece of legislation, Mr. Deputy Speaker, does. It adds integrity, it places a fiduciary duty and a responsibility on those persons who are deemed to be controllers. The law recognizes that those persons who are controllers has that fiduciary duty and they are responsible. And it's similar to for-profit companies under the Companies Act, where the directors hold a similar fiduciary duty. And the directors can also be found to be guilty of some sort of offense. So, Mr. Deputy Speaker, I reject that. The member for Oropuch East also indicated that some members of non-profit organizations may keep their files and their accounts in the back of a car trunk. And I'd say to the member for Oropuch East, well, what does that really say for the non-profit sector? What does that say for persons who must have confidence in participating in the non-profit sector, even as donors, where someone gives of their personal property towards a trust for some charitable purpose, some altruistic purpose, and that person receives those funds, receives that property, and instead of properly accounting and properly filing, keeps information in our car trunk. I am disappointed that the member for Oropuch East would actually make that point. The member for Oropuch East also was a bit disingenuous in saying that there's a woman who may want to raise funds for her child to further some sporting discipline or some other. The member clearly did not read the definition of a non-profit organization, where it clearly refers to a body of persons, whether incorporated or incorporated. Exactly. So the one individual by the mall who brings a sheet for you, asking you for a donation to buy a little football boots or to participate in some cake sale or the other, is not caught by this bill. And he knows that. So that's why I say he might be a bit disingenuous. But, Mr. Deputy Speaker, I'll get to some other points later down. So, Mr. Deputy Speaker, the passage of this bill, that is the regulation of the non-profit sector, is done to meet our international obligations to the Financial Action Task Force. These recommendations on anti-money laundering as well as counter-terrorist financing. And the 40 recommendations, Mr. Deputy Speaker, are recognized as the international standards for the combating of money laundering and terrorist financing and any other threats. And these standards must be adhered to ensure the integrity of not just our domestic financial system, but also the global financial system. And our failure to comply with these international standards, as the Attorney General has said time and time again, would lead to our eventual blacklist and exclusion from the global community through the ultimate sanction of de-risking. And we're dealing with recommendation 8 here today, Mr. Deputy Speaker. And this recommendation specifically requires countries to review the adequacy of laws and regulations that relate to the non-profit organization sector, which the country has identified as being vulnerable to terrorist financing abuse or money laundering. And as the Attorney General said, in our mutual evaluation report, recommendation 8 was rated as non-compliant and totally outstanding. It was found in that mutual evaluation, Mr. Deputy Speaker, that this jurisdiction had no adequate legislative framework for the regulation of NPOs, and there was no evidence of an anti-money laundering or counter-terrorist financing policy governing the non-profit sector. So this bill is here today, and I congratulate the Attorney General for bringing it to treat with the deficiencies, and to look at the vulnerability of an unregulated non-profit organization sector. So, Mr. Deputy Speaker, let us examine what is an NPO in order to understand why NPOs can pose very serious risk and very serious vulnerabilities. The NPO sector is at serious risk of infiltration and abuse with respect to money laundering and terrorist financing. An NPO is defined by the Financial Action Task Force very widely, and it's not so defined in the bill that is presently before us, as a legal person or arrangement or organization that primarily engages in raising or disbursing funds for purposes such as charitable, religious, cultural, educational, social, or fraternal purposes, or for the carrying out of other types of good works. It's significantly wider than the definition that is in the bill before us, and as well as the definition that is in the Companies Act. So in other words, it is an organization arranged not in the pursuit of profit, but in the pursuit of some other charitable or altruistic purpose for the development of the community. And there are 3 types of NPO, as the Attorney General alluded to. One's incorporated by Acts of Parliament, a non-profit company incorporated and registered under the Companies Act, and an unincorporated association. And Mr. Deputy Speaker, I treat with the unincorporated association as the Attorney General dealt very comprehensively with non-profit companies. Because an unincorporated association, as the name suggests, is not incorporated under the Companies Act or registered in the company's registry, and it is a very flexible and inexpensive way of constituting an association for charitable or altruistic purposes. It is an association created by its members in the pursuit of a common purpose. And these associations, Mr. Deputy Speaker, as you know, are allowed to open bank accounts and to enter into the formal financial system. For example, a village council, a residential association may take this form of organization, opting not to go into the formal route of registering under the Companies Act. And Mr. Deputy Speaker, these organizations are free to raise funds. They are free to participate in the formal financial sector. They can hold property in the name of the trustees as well, Mr. Deputy Speaker, and they are simply bound by their constitution and the bylaws that they, as members of that association, agree to. So, Mr. Deputy Speaker, the NPO sector is very largely unregulated. The non-profit sector is unchecked. It is unsupervised. And apart from whatever due diligence procedures that a banking institution may put, or the formal financial system may put on the deposits of these non-profit organizations, they can go about their activities without any supervision, any monitoring, any checks. And that, Mr. Deputy Speaker, is what makes an NPO very attractive for those wishing to abuse that sector and those organizations, criminals wishing to launder the illicit proceeds of their crimes through money laundering, as well as organizations looking to further terrorist activities. So, Mr. Deputy Speaker, let me just briefly look into the methods of abuse. And it's based on international case studies. Some of the modalities of abuse, as identified for these non-profit organizations, can be through the diversion of the NPO's funds. That is, the very nature of the organization of an NPO. It depends on a lot of volunteers. Persons come, persons go. And the very nature of an NPO, especially in our jurisdiction, background checks are not placed on those volunteers. How these NPOs can be abused for terrorist financing purposes, as well as money laundering purposes. The persons going out there and soliciting funds on behalf of the NPO may simply wish not to remit it back to the NPO. And they can, in possession of those funds, pass it on to some terrorist organization or put it towards some purpose aimed at furthering a terrorist organization. Or the very persons, the controllers, someone who is in charge of the financial accounting, may receive a remittance of those funds. And unbeknownst to any of the other members, or even the board of directors of that NPC or NPO, may very well go to the bank and transfer large amounts of monies, again, unbeknownst to anybody else, to in their personal capacity, affiliate terrorist organizations in conflict zones all over the world. Individuals may also pass themselves off as falsely representing NPOs. Mr. Deputy Speaker, there's also the abuse of the association's programs where, again, very little background checks are taken. And, for example, an NPO with an educational purpose, a charitable educational purpose, may hire someone, no background checks, no proper systems in place, and that person, you send them out there to deliver an educational program. And instead, that person may very well try and use their position to indoctrinate persons to the terrorist philosophy or the terrorist theories, indoctrinate and recruit them to join terrorist organizations. Mr. Deputy Speaker, another way of abuse, another modality of abuse is where support for terrorist recruitment can be disguised in the form of assistance to individuals involved. So there may be a non-profit organization. Persons go out to the wider society and they solicit funds to assist the needy. the poor, persons who are in need of assistance. When in fact, the persons who they are providing assistance to may very well be the families of recruited terrorist fighters who have gone abroad in conflict zones to join terrorist associations. And Mr. Deputy Speaker, with respect to money laundering, we all know that an NPO, as unregulated as it is ripe to criminals seeking to launder their monies. And I really want to cast no aspersions, but there are a number of churches that have sprung up, there are a number of schools, there are a number of organizations. The very nature of how an NPO is funded, the donations, depending on the type and the purpose, an NPO may be funded in cash. The cash funds, they spike, they go up and down. They're not, and it's very hard to track where, for the bank, it's very hard to track where those funds come from. And Mr. Deputy Speaker, it could very well be that a criminal who complicit with the members of a church may very well be able to launder the proceeds of his crimes through that church. Taking those illicit funds, passing it through the church depositing the proceeds of those crimes into the church's bank account. And very simply, the money launderer, and we dealt with it last time, so it also interacts with recommendations 33 and 34, which treats with transparency and unmasking beneficial ownership. When the criminal passes his illicit funds and launders his illicit funds through the NPO, and it goes into the bank account, the criminal can get back that money where the NPO can purchase a car, or can purchase a house, or can purchase land that now is in the sole possession of the criminal, because nobody is keeping track of this thing. The sole possession of the criminal, and therefore the criminal will enjoy the beneficial ownership of these very valuable pieces of property. So, Mr. Deputy Speaker, in light of these various types of abuses, the government is committed to eliminating the risk of abuse with the introduction of this bill that I wholeheartedly support. Part 1 of the bill treats with controllers. A lot of was spoken about that, and it really just identifies who is responsible and who can be liable where an offense is committed by a non-profit organization, who owes the fiduciary duty under the law. The bill also gives a very wide definition to the meaning of the word property, and I know the Attorney General went in at length on that. In Clause 4, Part 2, the Financial Intelligence Unit is now empowered with supervisory powers for the regulation of the NPO sector with respect to anti-money laundering and counter-finance terrorism and proliferation financing. But the NPOs do not now have to register with the FIU in the same way as credit unions and other listed businesses have to do. And that is by virtue of their registration, their mandate to register now with the Registrar General. Clause 5 sets out the formalities of registration for an NPO, and it also very usefully, Mr. Deputy Speaker, includes a completed anti-money laundering, counter-financing of terrorism, and proliferation financing risk assessment questionnaire, which will, by itself, sensitize the operators, the controllers, the members of an NPO of their many risks of abuse. Clause 6 allows for the approval and the grant or renewal of a certificate of registration And it also lists the bases upon which the Registrar General may refuse to register or renew an application. And Clause 7, Mr. Deputy Speaker, limits the time for a certificate of registration. A certificate of registration only lasts for 3 years. And therefore, unlike companies that may exist into perpetuity, or unlike certain charitable trusts that, by the way the trust is created, intends to exist into perpetuity, an NPO now can only exist for a period of 3 years, subject to a successful application for a renewal of the certificate of registration. And this by itself, Mr. Deputy Speaker, would also bolster and add to the integrity of the non-profit sector and create confidence in the entire sector for all its stakeholders and for donors. Clause 8 deems that all non-profit companies incorporated under the Companies Act will be registered and are deemed to be registered. Clause 9 sets out the information to be included on the non-profit organization register. And Clause 10 provides the reason for the cancellation of a registration where the NPO fails to fulfill its obligations under this Act, has breached its own constitution or bylaws, has breached in its duty as trustee to any of its donors, and where criminal offenses are committed in relation to the NPO. Very usefully, in Part 3, Mr. Deputy Speaker, Clause 14 places obligations on NPOs that proper financial accounts and records must be kept, and they must be kept for 6 years. Again, instead of placing these records in a car trunk, the records must be kept in a secure location and must be kept for a period of 6 years, because in some instances, it is significant trust property that these NPOs are dealing with. So, Mr. Deputy Speaker, a lot has been said already, and I don't want to protract this any longer. I am happy to support the efforts of the government, as well as the Attorney General, in fulfilling its international obligations in regulating and minimizing the risks of abuse in the non-profit sector. It is important that the non-profit sector remain credible and trustworthy to all its stakeholders and donors so that there remains confidence in the system. With the passage of this bill, NPOs and their controllers are now forced to be more diligent in the course of the delivery of its service. And that diligence, Mr. Deputy Speaker, would only redound to the benefit of our financial system, not just domestically, but our place in the global financial system and our place in the global community. So, Mr. Deputy Speaker, with those few words, I want to thank you for the opportunity, and I support this bill wholeheartedly.
I recognize the member for Caroni Central.
Thank you. Thank you very much, Mr. Deputy Speaker. I rise to make a contribution on this bill, the Non-Profit Organizations Bill 2019. As my political leader and leader of the opposition and my colleague from Oropouche East have both indicated, the good intentions of this bill cannot be ignored or denied. But there are serious problems with the bill. Many points of view were articulated on this side by the leader of the opposition, the member for Oropouche East. But I think two very telling points that they made was that, first of all, you had a situation here where for the objectives that were being sought, the good objectives that were being sought, to fight terrorism, anti-money laundering, basically corruption, the reach and the overreach were just too much. I think that is an important issue. And the second point that they were making is that basically in this overreach and dealing with the people sector, so to speak, a sledgehammer was being used to slam down a mosquito. And I think those are legitimate objections to some of the elements of this bill. Now, nonprofits are not organized for the business of making money. Generally, they are involved in charitable work or social work, but they can be involved in religion, education, science, research, environment, community, etc. But they are a source of social capital and an avenue for social capital development. This is an important part of society. And much research that has been done on the development of competitiveness, on the development of business, on the development of cohesion and competitive capacity in countries show that not just intellectual capital, but social capital is a critical factor in development. Now, organizations like these have to raise money. And to do this, whether you are a cricket club or a women's organization or a church, they can either get money from government or they can raise money from the private sector and from philanthropic individuals. So money is involved, although they do not make a profit. And once money is involved, the issue of trust becomes a key factor. For the donors who are donating money because they want their money to be well spent, and for communities that are served. And of course, if the government is giving money, the government wants accountability as well. So people in general want to know that the money is doing what it is supposed to do. So we acknowledge accountability as a key factor because donors want to know that the money is well spent. Accountability is good because it engenders trust. Government wants to know that its subvention are used for the purposes that are intended or at least articulated. For most organizations, it might be small money. For some, it might be larger money. And for others, significantly big money. It depends. And always the community wants to feel comfortable that money is being spent on the right things. So the issue is, how do you keep nonprofits, as identified in this bill, honest and accountable and doing what they were established for? So regulation is not an unreasonable thing. We are not objecting to regulation. In some cases, they use public money, as the AG said. Okay? In other cases, they offer public or social services. They establish the government wants to establish standards. They want to hold the organizations to account. And they want to establish a framework for monitoring and evaluating what they are doing. The purpose of regulation, therefore, given the nature of the work that nonprofits do, is to protect the public, to protect charitable donors, to protect the state from deception and malpractice of any kind. And I suspect that the government, in bringing this bill, also wants to put safeguards to protect people from themselves. because that is often a problem in organizations and institutions of any kind, whether it's this, a business, a political organization, an NGO, anything. It might be worthwhile to note, though, that government and nonprofits rely on each other. Nonprofits provide services to citizens, while nonprofits rely on the government for funding in cases where they are state funded. This is true of the business sector too, and nonprofits and the relationship between the business and nonprofit sector. Business people can't go out and do charitable work every day. They have their work to do. But they would be prepared to support a nonprofit if they did it well and came back in accountable terms to them. And the government also wants to see performance of that kind. Nonprofits do not pay tax. They don't make a profit, as I said, and many of them are exempt from tax. Many nonprofits, Mr. Deputy Speaker, are NGOs and CBOs, and they are involved in or dedicated to a range of sectors. This is what is known as civil society organizations. They could be in cricket and football, they could be in music, they could be environment, they could be in education, they could be religious organizations involved in various charitable purposes. It could be anything. Now, can civil societies, nonprofits, CBOs, NGOs go wrong? Yes, they can. Directors can ignore the mandate and intent and do what they want, contrary to the aims and objects of the organization they represent. The member for San Fernando East spoke to some of those issues. Power can be abused as it can be abused anywhere and everywhere else. Civil societies organizations are not exempt from this. It happens. The membership can be ignored or have limited involvement, and the leaders can run amok. Funds meant for public purposes or charitable purposes can be diverted to personal use of individuals or a clique. Accountability issues can be totally ignored. People can be irresponsible. Transparency can be undermined. The institutional aspect can be weak. Leadership can be authoritarian and dictatorial. Yes, bad things can happen. But despite whatever flaws, Mr. Deputy Speaker, is civil society important? That is the important question. Well, it is. And I think the fact that you want to have a bill to regulate it acknowledges that it is. But there is a difference, I think, in development perspective that reveals a certain perspective from the government that we do not support. And I want to say that our perspective on development with regard to NGOs, CBOs, civil society organizations is very different. You see, we see these civil society organizations as a vital part of democracy. We see it as helping to strengthen democratic participation. We see it as helping to close the democratic deficit in countries. Civil society can be an essential feature of good governance. It doesn't have to be treated as if it were a criminal class. So when the issue of regulation emerges, one has to consider balance. The need for regulation, but also the need for an encouraging framework to allow them to develop. The challenge becomes, Mr. Deputy Speaker, how to balance good practice and the use of regulations to support good practice and avoid tipping the scale to overburden these organizations so much that you stymie growth and development and weaken advocacy and the democratic process. It should be remembered that many civil society organizations are based on volunteerism and advocacy for a cause. It flourishes in an environment in which enlightened self-interest can be pursued. The clash of enlightened self-interest in the society is essential for the growth and development of democracy and the democratic process, and the facilitation of give and take in the exchange of ideas, and the building of consensus. I crave your indulgence, Mr. Deputy Speaker, to draw on an article I wrote many years ago in 1997, and which was published in the Nordic Journal of Latin American Caribbean Studies.
Silence.
And published in the Nordic Journal of Latin American and Caribbean Studies in 1998. The title of the article was Globalization, Opening Spaces for Civic Engagement. Now, the focus of the article is on the role of people and the people's organizations in the development process as part of a sustainable approach to building a society. Now, this was 1997, Mr. Deputy Chairman, Mr. Deputy Speaker. And as you know, the talk today based on 2017 from the United Nations is about 17 Sustainable Development Goals. Now, in the article, I stress the importance of the stakeholder approach to the process of political participation. As all members will know, the Nordic countries are very strong on civil society engagement. They are very strong on stakeholder participation and consultation as practice. So what I had to say in 1997 made sense
Members,
to the editors of the Nordic Journal focused on Latin America and the Caribbean. And this is some of what I said.
member, 1 second. Members, please. I would like to hear the discourse of the member for Caroni Central. Yes. So please, the crosstalk across the floor. Minister of Finance, Oropuchis, please.
Yeah, thank you very much, Mr. Deputy Speaker. Civic engagement has always been an important area of concern in the context of development. In most countries, there's a rich tradition of community action as a force for change in both urban and rural contexts. Today, civic engagement is described in a number of ways. Whether one describes the phenomenon as community building, civic institutions, social capital, citizens' organization, non-government or civic engagement, the concern is really about two things: people's participation in the socio-economic and political process, and the social infrastructure required to support the democratic decision-making process. One commentator writing on activities in the 1970s and 1980s has pointed out, and
Mr. Deputy Speaker, stand in order 48 point, please.
This is an intellectual engagement.
it is simply because you have no ideas, you have no philosophical basis, and you are a backward political party taking the country in the back.
Okay, member for Caroni Central, I have not ruled as yet, but I'd like you to retract the statement you just made, please.
Sir,
Pardon?
I do.
Proceed. Tie in your point as quickly as possible, please.
Yes. And the commentator that I quote here is saying, it was really the government that set down the requirements for participation in the community development process. Tensions between the centers of power and the edges of society soon appeared. So that in this business of the emergence of the civil society organization, there was a direct tension between government at the center of the power and control process and organizations trying to find their space in order to assert their positions on particular issues. Now, I will simply read a few lines here more. If we are to take a sustainable development approach to Caribbean society, then the ordinary citizen and the organizations in which they assemble must play a pivotal role in the development process. Part of the role that such organizations and institutions must play involves embracing responsibility for the social, ecological, and economic sustainability of societies in which they live. And therefore, what we have to do is to not see civil society organizations as terror organizations, but organizations that sustain the social fabric and that sustain the political democratic process. And the philosophical position that they have is what influences a bill such as this. And I will explain again, and I ask for your protection, Mr. Deputy Speaker, because I know that they are going to stand up again or raise issues again. Because you see, in our manifesto of 2015, all right, we talk on page 17, we talk on page 17 of strengthening governance and institutional arrangements. The state provides the institutions and infrastructure that enable the economy and society to operate. Its ability to carry out...
Standing order 48-1 again, please. Mention a clause at least.
The role of the scabby rambling.
Overruled. Proceed.
To carry out these functions has an undeniably profound impact on the lives of citizens. And I close here as the voice of the people will continue to be heard as we adopt policies and programs guided by multi-stakeholder partnerships for national development. So we see civil society organizations as developmental partners, and in fact we say so in this document. We see them in the context of empowering the people. We see them in the context of the way you build and organize and manage a society. You have government, you have business, you have labor, you have civil society, all four working within a framework for national development on the basis of a vision. We also see them in terms of the development of volunteerism. And that is why we have views such as home-owning democracy, stakeholding democracy.
Cannot, as the draft of this bill, find any relevance. I'm asking for your humble consideration.
What is this standing order?
48-1, you there? I apologize.
Member for Naparima, I didn't think the question was directed towards you. Please, please, please. Member for St. Anne's, please. Members, listen.
Follow my example, please. Follow my example, please. You're speaking in Bok language. Hey, you get baptized. You all can't behave like me.
Okay, all right, members, listen. From now on, no crosstalk whatsoever. Okay, if that's how you all would like to be what you all would like me to subject you all to, no crosstalks. Member for Caroni Central, tie in your point and close off accordingly.
I'm tying in my points, Mr. Deputy Speaker. It is just the fact that I'm saying to them that they have no basis of philosophical organization of thought for bringing this legislation, which it is the thought process that I'm attacking in this legislation. I am saying that it is completely skewed, Mr. Deputy Speaker. So in this particular manifesto that I mentioned, we mentioned social capital, which is what I talked about, participatory democracy. And when you look at development today, and these things are instruments of development, all these civil society organizations, what does it involve? It involves institutions that focus on the economy. It involves the environment, of course. It involves building of people and community. It involves inclusion, participation, opportunity, equity, collaboration,
Deputy
cohesion.
Speaker, Standing Orders 55(1)B and 48(1).
Please. What we say, no cross talk.
All this has been covered.
Member for Naprima, stand and apologize to me clearly. Stand and apologize.
I apologize.
For what?
Member for St. Joseph, please. Member for Toko Sandy Grande, please. Overruled, proceed.
Thank you very much, Mr. Deputy Speaker. Thank you very much. So, Mr. Deputy Speaker, the whole approach here is one which should see civil society organization, which is what this bill is about, Mr. Deputy Speaker, is one in which civil societies organizations should be seen in the context of economic participation. It should be seen in the context of
which Oropouche East and which Separia have spent a copious amount of time on. Civil society participation, the need for that aspect, the third leg of the society kicking, the consultative aspect, Mr. Deputy Speaker, I'm asking kindly, I've taken copious notes which I can share. This has been repeated. This is the 5th time it's being made from 3 different speakers. I ask for your ruling.
And as I rule, AG, yes, it may be on the same particular topic, but his points are different from what was said earlier. So overruled, proceed.
Thank you very much, Mr. Deputy Speaker. It has to do with political empowerment, the building of social capital, the building of community power and the strengthening of people empowerment, and it has to do with using these instruments, these organizations, to help people to learn and grow and develop so that you build that social capital accumulation in the society. Now, this bill, not the non-profit organization bill, is hostile, Mr. Deputy Speaker, to this kind of thinking, which is why they are getting up to oppose me. This is why they want me to shut up. This is why they want me not to speak. It is hostile to people and people's organizations. I wonder...
Mr. Deputy Speaker, Separia, Oropouche East, hostile to Kucharan Trace, hostile, Mr. Deputy Speaker, all of this has
Mr.
been
Aegis,
said.
please sit down.
He is on a standing order. He has the right.
Yes.
You cannot get one like that, please. AG, proceed. What you make your point?
Mr. Deputy Speaker, with the greatest of respect to my learned colleague, whom I have respect for, lest he get upset, these points have been canvassed already from multiple angles, Mr. Deputy Speaker. I consider, under the purview of Standing Order 55(1)B, that we are bordering on tedious repetition, Mr. Deputy Speaker. We've taken this at 6 different angles, Mr. Deputy Speaker, but respectfully on the same point.
Okay, again, Carney Central, you have now started the point. Let me hear what road you are going down, and I will then determine. Right, so proceed.
I was just saying, Mr. Deputy Chairman, Mr. Deputy Speaker, sorry, that the reason they are objecting so much is because the perspective that they have is very hostile to people's organizations. And you would not recognize the members sitting in the front bench here today from the founder of that party, Eric Williams, who talked about a people's sector and who talked about a people's charter, one in 1956 and one in 1970. And what this legislation is really a legislation to cripple an element of the people's sector. And they don't even have the self-knowledge of that. And even if they did, it wouldn't bother them because the track that they are on have nothing to do with ordinary people in this country. The network of civil organizations.
1B. This is exactly the submission from Oropouche East, Mr. Deputy Speaker. I have yet even hear a clause of the bill referred to. We are now 20 minutes into the presentation, Mr. Deputy Speaker, and we have urgent business to do. I'm asking for your ruling.
Again.
Right, so member, again, I would like you to close off this point and move on. Right, I've seen the road that you are going down, and again, it's bordering similar with regards to what have been said previously. So move on to your other point, please.
Sir, with all due respect, I'm not repeating anything here, you know.
I have ruled Caroni Central. I have ruled on this occasion.
The network of civil society organizations, whom the AG said he engaged, sent to them documents, a document that was done by a consultant and indicated concerns about a 2018 bill that they circulated. I don't need to go through this bill clause by clause, Mr. Deputy Speaker. The AG did that. The leader of the opposition went through significant clauses having to do with the distribution of power and the exercise of power under the jurisdiction and the conflict between certain bills in the country that have been passed by this parliament. My colleague from Oropouche East dealt with other matters having to do with power overreach in the bill and taking a sledgehammer to kill a mosquito. I don't need to go in the clauses for that. But the network of civil society organizations acknowledges that there is need for greater scrutiny and the need for an intervention. They recommended 4 actions. I won't read them here, but they recommended 4 actions that they feel might make it better, make the bill better, and make any kind of organizational strategy for scrutiny better. Now, the advocacy paper, Mr. Deputy Speaker, is not a response to the legislation.
Honourable member, your 30 minutes has expired. You have an additional 15. You care to avail yourself?
I would like to.
Right, kindly proceed.
Mr. Deputy Speaker, will I get any time for the stoppages?
Kindly proceed.
The advocacy paper of the network is not a response to the legislation. This advocacy paper came out of an EU-sponsored consultancy to strengthen the civil society sector and to make it more accountable and responsive. So the AG is not the only one thinking about this. The government is not the only one thinking about this. The sector itself is thinking about it. But the civil society, through the network of NGOs, did submit comments on a 2018 draft. I don't think any of those comments that were submitted were taken into account, Mr. Deputy Speaker, in the preparation of this legislation. And I could ask the AG to get up. He likes to get up a lot. Ask him to stand up now and tell me whether, in fact, any of the issues were taken into account.
Yes, they were.
I think a careful examination of the bill and their submissions would show that that is not the truth.
Standing Order 48-6.
Member, you care to rephrase or retract that statement, please?
No, I will say, Mr. Deputy Speaker, that there is a wide gap between what this bill contains and the submissions by the members of the civil society.
But the statement that you made, I would like you to retract it. The statement that you made, I would like you to withdraw it, and then you can make your new statement.
Well, if you want me to say that retract that it is not the truth, I will do that, Mr. Deputy Speaker.
Retract it, member for Caroni Central, and then you have the privilege to say whatever you want after.
I will retract it. And Mr. Deputy Speaker, I want to see how the AG will get up for this one. You know, we had a situation in which you had an Attorney General of this country having to answer a situation in which a building owned by him.
Standing Order 48-1.
Right. Remember, listen. I want total relevance with regards to the bill. I am not tolerating going down that road this afternoon.
Yes, well, I am going to make it relevant. Because when the AG receives his rental, it is from public.
In Order 48-1 and 48-6.
You are ridiculous. You all are ridiculous.
Okay, members, can I have my turn now? Member for Caroni Central, I am not allowing you to go down that road. Pronto. Proceed. Proceed.
The money that is paid is public money, Mr. Deputy Speaker.
Hold on. Member, again, I have ruled. As the Speaker in the chair, I have ruled. If you are not willing to abide by my ruling, we will then take it to another level. But I am not allowing to go down that road. I don't even want to know whether, in terms of the relevance, in terms of how you're going to tie it in, I am not tolerating it. Proceed.
Okay, Mr. Deputy Speaker. Now, there is no problem with regulating the civil society sector. And civil society welcomes it. That is what I try to point out from the documents of the CBOs. And we in the opposition welcome the reality of regulating the sector. We know that. The question is what kind of regulation and what purpose is the intent of regulation, and how you arrive at the regulation framework is important. We need to understand, Mr. Deputy Speaker, the context and the emergence of NGOs, CBOs, and civil society organizations in our country, and their strengths and weaknesses.
Mr. Deputy Speaker, Standing Order 55-1B, the member himself has alluded to this no less than 5 times in his presentation. Siparia mentioned it. Oropouche East mentioned it. 55-1B, please.
Member, again, on this occasion, I'll have to uphold the standing order. I'd like you to move on to the other point, please. On this occasion, you have to move on.
Mr. Deputy Speaker, I'm summarizing some of the points that I made. I'm trying to bring my discussion to a close. I'm trying to make a point. I feel that the government is being unreasonable, Mr. Deputy Speaker, and you cannot uphold them in that. I mean, your job is to arbiter in a fair manner.
Member, not to go down that road. I am saying, right, in terms of the tedious repetition, right, in terms of the same point that you're going to come with that you have started. I'm saying to move on to your other point. That's all I'm saying.
Mr. Deputy Speaker, I am not sure that the interests of this non-profit organization bill is about organizations, or it's about civil society, or the development of people's organization. In fact, I'm sure it is not. It is about a uniform registration process. It is about establishing and maintaining a register. It is about rules and regulations for nonprofits. I find it surprising that the supervisor of the nonprofit organizations is the FIU. The banks in this country are supervised by the central bank. And if there is an issue, they flag it. All right? The insurance companies, they operate in the context of the inspector of banks and insurance companies in the central bank ordinance. We don't have any such thing for the credit unions. We don't have any such things for cooperatives. Why is it that we are treating this sector in the way that we're doing in the FIU? And Mr. Deputy Speaker, I am more convinced now than ever, given their own response to my approach of this as a development issue, which has miscarried in terms of the legislation, that there are nefarious purposes behind this bill. I believe that they want to single out.
On Standing Order 48.6, Mr. Deputy Speaker.
How could you say that?
Nefarious.
We are nefarious.
Remember, again, find a different word, rephrase.
There are sinister purposes behind it.
6, Mr. Deputy Speaker.
Naparima, I am not recognizing you at this time. Member for Carney Central, again, a different word, a rephrase. Come on, I know you can do better than that.
He was a principal.
There is a
Silence
very big
on the
gap.
government side.
There is a very big gap between the stated intentions and the real intentions of this bill. I think that this bill could be abused and used for political victimization. I believe that this bill can be used and used for oppression. I also believe that this bill can be used to get information.
Member for Oakwood East, if you are sitting in that chair, I would not like to hear you, please. Okay. You are sitting? Nice. Proceed.
So, I think that there are tendencies that create opportunities in this bill, given the FIU on the one hand, given the structure of the Minister of Legal Affairs in this particular bill. All the Attorney General referred, I think, to the Australian bill, the Australian situation. And all the references to Europe, to Australia, to Canada, to the United States, make it very clear that the way you treat with this sector is as a developmental sector. Secondly, that the way you treat with regulation is through an independent authority. And the way you deal with matters having to do with terrorism, etc., which is what they are trying to do in relation to the European Union requirements, is that you find a way of dealing with that as a particular situation, not as a general paintbrush. This bill basically assumes guilt of everyone involved in the NGO sector. My constituents, organizations in my constituency, are national organizations.
Remember, again, in terms of repetition, again, that was covered already by all speakers. with regards to the various NGOs in their various areas. So again, another point.
Mr.
Come
Deputy
on,
Speaker.
members on both sides, Laventille West and also Couva North, please.
Mr. Speaker, so if I mention the Red Cross or I mention that organization that is helping Venezuelan refugees.
Mr. Deputy Speaker, Standing Order 55(1)B.
Please, please. Again, member, in all fairness.
Are we going to mention every NGO?
Member for St. Joseph, in all fairness, member, you have been given on many occasions the opportunity to expound on whatever you had to say this afternoon. And
That's
please, when I now rule, I want you to abide by my ruling. Okay? You have been given numerous opportunities earlier. When I rule now, I would like you to abide by my ruling. Proceed, please.
But I have abided by your ruling. Every rule that you've made, I've lived by it. Okay? I am not accusing you, sir. I am talking about the government and their behavior, which I'm entitled to do. The situation that we are in now with this bill is, I would like to join the leader of the opposition and my colleague from Canada Central in saying, from Oropouche, in asking to give consideration to the position of the NGO sector, who I know have written to the AG asking for time to engage on this bill and that they would like to contribute to the bill. And we on this side feel that there are many things wrong in this bill which need to be corrected, Mr. Deputy Speaker. And we feel that if the AG were to hold his hand, listen to the people,
We have 2 more minutes.
make the adjustments that are necessary, we are going to have a better bill to regulate the sector. But you cannot come here, Mr. Deputy Speaker, as the AG has come and simply taken the entire civil society sector, all 8,000 or 9,000 of them that he mentions, and come here with a broad brush and paint them as if they were a criminal class. I think that there's something wrong with that. I think where you need to really have the regulation is here. If the state is giving $200 million a year to the NGO sector, how is the state being held account for that? And how do we determine that who they are giving the money to are the right people in terms of what they say they want to do and what the government's policy is? Shouldn't we have accountability for that particular issue so that the state would answer how it is spending public money to give it to NGOs? Shouldn't we ask that? Isn't that an important question for $200 million? Shouldn't the state be more accountable as they are asking the NGOs to be accountable? I think that is very important. That's why I was raising the other matter of public money. Because, Mr. Deputy Speaker, I think this legislation is all skewed. I think the whole intent of it is not what is being said. And I think because of that, the draconian provisions cannot be allowed.
Well said. Thank you, Mr. Deputy Speaker.
Mr. Deputy Speaker, there have been a few serious interventions.
Members, I have ruled. I have ruled. Hold on, 1 second. 1 second. Both have your feet. Princess Tong, you have identified, also Laventille West had identified, if that's the role that you want to play. The AG stood up soon after I made the ruling. So I recognize the AG.
Mr. Deputy Speaker, if I take away what I call the traditional play of the UNC, the opposition, which is first mantra, the bill is unconstitutional. Second one, need more time. Third one, create pandemonium and panic amongst simple people by confusion and misrepresentation of the law. And then lastly, by
improper motives. What? He outlined three areas of improper motive that we are trying to create panic in the society. I am not doing that, sir.
Member for Naprima, what word you don't like? Panic? What word you don't
The word
like?
where he said that there are three motives every time we come up to create panic in the society and pandemonium in the society, or words to that effect.
Overruled.
Thank you. Mr. Deputy
Speaker, let me be very careful this afternoon to say I intend to criticize vigorously the arguments presented this afternoon. Not the personalities behind the arguments, but I intend to criticize vigorously the arguments presented this afternoon. I was saying that the arguments presented by Siparia, by Oropouche East, by Caroni Central involve the traditional ports of call for the opposition by way of argument. Firstly, that legislation that is brought is supposedly unconstitutional. Secondly, that the legislation is designed supposedly against the interests of personalities and people, simple folk in this country. Thirdly, I intend to criticize the fear-mongering that the arguments are no doubt intended to create. Now, Mr. Deputy Speaker, I want to say this. I watched the member for Siparia read from a speech, a prepared speech this afternoon. And I want to say that the honorable member, past Attorney General of this country, past Minister of Education of this country, past Prime Minister of this country, was deemed to be deserving of the award of Silk. As a person in public life, occupying the office of Prime Minister, the Prime Minister gifted herself the award of Silk. And as a leading member,
he is saying that the member for Siparia gifted herself the silk. That is wrong. That is erroneous.
Okay, listen. Naprima, you just have to make the point to me and I'll rule accordingly. Retract and... listen.
What?
AG, listen.
No.
Honorable AG, I would like you to retract that statement. Right?
And if you're ruling.
The same one that the member for Naprima spoke on with regards to the silk and so on. I'd like you to
I will retract.
yes.
Once
you have decided.
Yes, sir, I retract. Let me explain this.
Mr. Deputy Speaker, with respect.
Speaker, you should stand if you're ruling rather than sit down.
No, the speaker has to stand and rule. Of the argument raised by Caroni Central about propriety. I am saying as a matter of fact that the Prime Minister of the Republic of Trinidad and Tobago is the only person under law who can grant the status of silk in this country. It's a fact.
The relevance to members I am ruling. Have your seat. I can treat you all how you all are trying to treat me in this chair. Please, AG, the relevance, move on.
Relevance to what, sir? I will move on. Just guide me.
Move on. Move on to your new topic, Mr. AG.
Yes.
Mr. Deputy Speaker, I will move on. I will move on to the point of propriety in public life. I'm answering the submission of Caroni Central. May I do so, Mr. Deputy Speaker? Thank you. In answering the submission, as I'm entitled in my wrap-up to do, so I'm grounding my relevance to be careful to make sure that I don't offend any ruling or the rules of the Parliament by standing order. I am responding to the allegation of the need for this legislation to coincide with integrity in public life. And I am saying, as a matter of fact, in answer to the member for Caroni Central, he having raised it for a full 15 minutes, that the award of the status of silk in this country is only done constitutionally by the Prime Minister. By the Prime Minister. You must rule.
Let's move on to another point for me, please, now. I know you are learned enough to move to make another relevance towards that particular issue. I have ruled on it, so it's only fair that I do it that way.
Sure, Mr. Deputy Speaker, I'll be guided. I move on. I understand I'm causing pain to my colleagues.
Okay.
I'm causing pain to my colleagues. I respect your ruling. I will move on. Do so, don't like so, when the truth is said. So, Mr. Deputy Speaker, the arguments offered, be they in hysteria, be they in a vein which can be interpreted to cause panic, and be they in terms of the submissions read by Siparia, because I was quite surprised that Siparia had to read her entire submission. The position in relation to this bill must now be answered. Let's start with the allegations by Siparia that this bill somehow requires a constitutional majority. Siparia was very clear in her submission to say she accepts that the bill is a simple majority bill, that the bill does not traverse any 3/5 rights contained in the Constitution pursuant to sections 4 and 5. And very importantly, the honourable member went on to say that there were anomalies in the bill which causes one to have concern about. If you don't understand English, Naparima can't help you. So, Madam Speaker, the honourable member for Siparia, in raising the issue of constitutionality, sought to ground her argument after having made a submission that the bill does not trip any 3/4, 3/5 majority rights, sections 4 and 5 rights in the Constitution. The honourable member went on to make most astounding submissions in law. First one that stands out. The honourable member for Siparia said it was improper and a conflict of interest for the FIU to be the regulator as proposed by Clause 4. That is what the honourable member said. The honourable member, in making that legal submission, having gifted herself senior counsel as she properly did as Prime Minister,
Madam Speaker,
standing as a member of the
on a
inner
point of
bar.
order 48(1), the Attorney General keeps raising this issue about silk, and the Deputy Speaker ruled.
Attorney General, I believe the Deputy Speaker has indicated that you should take a different route. So there's continuity.
Yes.
Please abide by that.
Senior counsel, the member for Siparia, in making her legal submissions this afternoon, having received silk to become senior counsel in whatever fashion that happened, senior counsel made the submission that I withdraw.
A different way.
I withdraw.
But please.
Yes. It's
Okay.
a touchy subject, I understand.
Yeah.
I withdraw.
So let's continue.
Yes. I can.
Yes,
1 minute, please, okay? Because even though I was not in the chamber, I am seeing a developing trend that when the presiding officer rules, members stand up and either contradict or add. That needs to be nipped in the bud now, okay? And it applies to both sides, all right? Continue.
It's full-time duty end?
Your original time is 7:05, and you have an additional 15 minutes.
Thank you, Madam Speaker. I'll make haste. Madam Speaker, I'm answering the submission of Siparia, which was, in my respectful view, a very poor submission on the law. It was scandalous in the sense of legal argument, not in terms of the pejorative sense attributed to a member. I am not speaking about that. The argument was frivolous and vexatious, and I will see how. The honourable member stood up to try to tell us that the FIU was in a conflict of interest as a regulator. The honourable member went on to say that there is no entity that is in that circumstance. But, Madam Speaker, I am shocked to see in black and white the Proceeds of Crime Act, Section 2, providing in the first schedule to the Proceeds of Crime Act the following listed businesses which are to be supervised by the Financial Intelligence Unit. 1, real estate agents. 2, motor vehicle sales, gaming houses, pool betting, national lotteries, online betting games, jewelers, private members clubs, attorneys at law, accountants or other persons performing functions of accountant or other independent legal profession, an art dealer, trust and company service provider. Madam Speaker, the Financial Intelligence Unit's powers are to be found in the Financial Intelligence Units Act, Chapter 7201. I go straight away to Section 8. Section 8 says, the functions and powers of the FIU shall be responsible for collection, financial intelligence and information, the analysis, dissemination, exchange of financial intelligence, information among law enforcement, financial institutions, listed businesses, which I just read, and internationally, and shall exercise functions given to it under the Proceeds of Crime Act. The FIU shall receive suspicious transaction reports, activity reports, the functions assigned, etc., are as set out in the law. The Financial Intelligence Unit, birthed in 2009, was set up as an administrative version of that, number one. It is not law enforcement, and it is not the third type, which is the hybrid type. It has stood as the law since 2009 with the functions described in 2008. Secondly, Madam Speaker.
Member for Naparima, if you want to make an interruption, you know how. If you cannot regulate yourself in here, I suggest you take a little walk, control yourself, and come back. Listen to me.
Are you suggesting I take it now?
I am not suggesting anything to you. Okay, and we're not in a conversation. Either you understand what I'm saying or you suffer the penalty. Attorney General.
Sections 9, 10, 11, 12, onward, and 18 in particular, identify in chapter and verse the coercive, pseudo-investigative, reporting factions that the FIU exercises. So, Madam Speaker, to hear learned senior counsel, the Honourable Member for Siparia, make a submission that the FIU, in being the regulator under Clause 4, is in some unique circumstance never found in Trinidad and Tobago before, belies the title of research and diligence with respect to preparation. I am sure the Honourable Member herself is not guilty of that. Perhaps it was the speechwriter, because the Honourable Member read from copious notes prepared. So, Madam Speaker, perhaps it was wrong, but I'm correcting the record now. The investigative functions, the powers of dissemination of information, the collection of suspicious transactions, the analysis, the data, all of that happens in the FIU and has happened since the year 2009. More than that, they happened under the watch of the member for Siparia as Prime Minister of this country. Under umpteen amendments to the Financial Intelligence Unit Act. The Honourable Member did not seek to change the law, but today arrives to say that the FIU, by being a regulator for non-profit organizations, is acting in a capacity which is unlawful, to the point where the Honourable Member says that the opposition will challenge the law. I'd love to see that. But the Honourable Member says that this circumstance is now unusual. So let's go to what would be supervised by putting the regulator in Clause 4. Madam Speaker, I've noticed a very feeble attempt. Now, I find Oropuchi very entertaining in his contribution. He's made a few points which I will address, which I think are sensible areas to be addressed. But, Madam Speaker, if I take that aside to listen to Siparia say that there's an unconstitutionality in the FIU acting, and then to hear Caroni Central say that the minister being involved in the FIU pollutes the FIU, Madam Speaker, the FIU, Madam Speaker, is an autonomous entity from the Ministry of Finance, so categorized and rated by the Financial Action Task Force, so insulated that the FIU can't tell the Minister of Finance anything other than, I want more money, by way of appropriation cycles. But, Madam Speaker, that is well known to my colleagues opposite. But, Madam Speaker, when we get to the functionality of the regulator, the FIU, supervising non-profit organizations, let's look at what's involved. The scandal or the panic that one can walk away with from the arguments is as follows. Some small person raising money, a cake sale person, some other entity, a sole individual, is going to be put out of this business. Madam Speaker, let me go to the law. The bill before us says a non-profit organization, this is in clause 3, means a body of persons, whether incorporated or unincorporated, which, and there are 3 subsections, A, B, and C. You must combine all of them. You must be established primarily for certain purposes, patriotic, religious, philanthropic, charitable, etc. And you must carry on business without pecuniary gain to its members, except as reasonable compensation. And you must restrict the use of any profits or other accretions to the promotion of its purpose. That clearly does not include the cake seller, the sports goods raiser, because they will never be registered as non-profit organizations because they are not making declarations of trust. And I would like to say that the contribution by San Fernando East today was scholarly and stellar. Because as early as 1601, under the Charitable Uses Act, it has been determined that the element of charitable purpose in 1601, take that law forward, now in non-profit organizations, that three-pronged combination, that excludes the vast majority of entities. And for the Honourable Member for Caroni Central to say political parties are going to be included, please refer to page 5 of the bill, correct, together with page 4, and just read the English language.
But
Madam
would
Speaker.
the member give way?
No, I'm not. Read the English language, Madam Speaker, because...
Member for Caroni Central. Member for Caroni Central.
Madam Speaker, so the Honourable Member, in terms of the...
Member for Caroni Central, I'll give you an opportunity to retract that outburst. Okay, I'll give you an opportunity to do that.
You mean when I asked you if you heard?
On your legs, on your legs.
You mean that?
I am giving you an opportunity to retract your outburst. Please do it. It's your option.
I retract, Madam Speaker.
Thank you very much. Attorney General.
So, Madam Speaker, the definition of non-profit organization is very clear. It is a three-pronged combination. You can only enter that basket if you qualify under the 3 limbs. It excludes, therefore, the vast majority of purposes, and it does not include political enterprise. It does not, because it is nowhere in the definition section. And I can state now that as a government, Madam Speaker, we will be bringing campaign finance legislation to Parliament this year in this session. So, Madam Speaker, to make that argument, Siparia, Caroni Central, is really beyond the bounds of reason. Madam Speaker, I heard a submission which I think needs to be answered. It was sensibly put by Oropouche East, that the controller, who is the person identified in this law as having liability. Oropouche East asked a sensible question. Is this definition too wide? I'm paraphrasing, forgive me if I got it wrong. Is this definition of controller too wide such that the controller can be subjected to undue punishment? Because there are offenses under this legislation. And I'd like to say, it isn't in the example given by Oropouche East, the most senior person in the point, to be registered as a non-profit organization, Madam Speaker. You have to approach the registry, apply to be registered, meet the qualifications of the definition, the 3-pronged qualifications, be more than one person, and you have to say who your controller is. There's no high intensity understanding by guessing who the controller is. The controller is a declared person in the registration form. So to say any and everybody needs to be worried because you might be the controller and you facing offenses, Madam Speaker, that belies the process of registration from a point of logic and law. And that's why I find Siparia's submissions so outstandingly difficult to digest, Madam Speaker. Madam Speaker, let us go a little bit further into the arguments raised. Let's go to the consultation point. Madam Speaker, thankfully, the member for Pointe-a-Pierre passed me a letter supposedly addressed to me 27th of March 2019. I have not received this letter, and I'm seeing a few entities, including United Way, saying, put this bill off to the end of April. Let me deal with this. I have written correspondence from United Way, passing commentary. In fact, I can say I spoke to one of the members of United Way. In my piloting, I gave him a compliment for contributions, Mr. Ian Benjamin of Senior Counsel, my dear friend, I confess, somebody I have great regard for. So, Madam Speaker, number one, don't bring that letter by me. Number two, we have been in consultation since 2016, 17, 18, 19. We circulated legislation. We received comments from stakeholders. Stakeholders included Center for Information Communication Technology, Flaming World Ministry, National Islamic Counseling Services, Catholic Commission for Social Justice, University of the Southern Caribbean, Citizen Security Program, strategic entities. We went through British High Commission, but I won't count them, Nur Islam Masjid, Rotary Club of St. Augustine, National Muslim Women's Organization of TNT, Inner Wheel St. Augustine, Vision on a Mission, ILSCA. Went further, Madam Speaker. At our hearing and public consultation on April 30th, 2018, 1 year ago, where 138 persons attended, we had CSO for Good Governance present, Dr. Jennifer Sancho. 1 year ago, April last year, in our anti-terrorism events on PVE, CVE, where we address these issues amongst a number of stakeholders, where we have received 3 years of preparation, 2 years of consultation. We're now being told by the opposition, press pause, don't come with this bill. Unconstitutional, they allege. Not enough consultation. Siparia literally said, go back and talk to the thousands of people, is what Siparia said. Madam Speaker, the fact is there has been wide-scale publication. But Madam Speaker, the reason for pushback, I dare say, and this is my own submission, is that I fear that the habitual opposition that we get from the sitting opposition to any piece of legislation is usually just to make sure you don't pass law. That's my submission. It may not be their intention. That's the way I perceive it. But Madam Speaker, that is to be exacerbated by the following example. Siparia says to us, go and get an independent commission. You see this thing about the court? That's too expensive. Madam Speaker, it's too expensive according to the submission. Siparia says the AG has said there's approximately 9,000 entities. That's too bad for courts. Don't take the court process. Expensive, time-consuming. At the same point in time, Siparia, having sat in successive governments when the Companies Act was in place, must know we have 104,000 companies on the register. And of the 104,000 companies, guess what the root and remedy is? Court. Go to court, deal with your rights, and deal with it in that forum. So it wasn't good enough to treat with, under Siparia's tenure as Prime Minister, etc., for 104,000 people for companies, but it's not good enough for 8,000 entities. I can't reconcile the logic, Madam Speaker, respectfully. Secondly, the honourable member fails to take cognizance of the fact that it is the due process and court of law when you're treating with property rights that makes the difference between constitutionality and lack of constitutionality for lack of proportionality. Due process, as it is anchored in our Constitution, is a fundamental aspect of our Constitution. And to take it out of the domain of the court is to invite scandal in terms of proportionality. Respectfully, Madam Speaker. Madam Speaker, the British exercise in having an independent charity does not take account of the fact that if the FIU was not the regulator, and if you were putting someone else as the regulator, Madam Speaker, what are they going to regulate and how? The entity to look at FIU structural types is the FIU. We have the central bank, we have the insurance falling under central bank, and apart from central bank, SEC, we have the FIU. They all have powers of intrusion on a 3/5 majority basis. If we were to create a new entity to replicate the work of what the FIU does, we had to bring a 3/5 majority bill to create those powers, to create that kind of supervision. Worse than that, you have to recreate and duplicate the AML CFTPF funding, Madam Speaker. So the UNC knows very well as an opposition what they are doing when they say, don't use the FIU. They are inviting a chaos approach in terms of the legislative process involved to passing law like that. So, Madam Speaker, if the FIU can regulate all of the listed entities on the first schedule of poker, all of them, why is it inappropriate for the FIU to regulate non-profit organizations? Why? You see, Madam Speaker, first of all, you're not in the bucket unless you qualify by definition. But secondly, the only thing that I consider odorous in this bill is the fact that you will have to produce audited financial accounts, Madam Speaker. Clause 15 of the bill. But, Madam Speaker, we have set a threshold, which was another point raised by Oropouche East. We have set a threshold, and I want to publicly thank the Minister of Finance, because it was his political scrutiny and his involvement as Minister of Finance in scrubbing this law who said, listen, we do not want to catch churches, regular entities, charities, sporting clubs, small man, pepperoti people. We don't want any of them in this auditing basket. If your threshold is over 10 million Trinidad and Tobago dollars, Madam Speaker, then I respectfully suggest you ought to be with an accountant on board. And I will say that in my conversations with Senior Counsel Benjamin from United Way, he agreed that they were looking at that threshold marker, and he did make the point to me in his submissions, look, we're happy to see the threshold at a higher level because it's hard to have auditors. You usually rely upon a donation of services in the sense of gratis work, Madam Speaker. So we have taken the careful and prudent step to put a threshold argument inside of there, Madam Speaker. Madam Speaker, I've given you the consultation. I've given you the issue of constitutionality. I have dealt with the ridiculous intellectual submission that the FIU is in a conflict of interest position by demonstrating the laws of the Republic of Trinidad and Tobago. The Honourable Member asks Siparia about the proclamation of laws. The Honourable Member said, I've looked for the motor vehicle and road traffic and the declogging of the criminal system, and I'm not seeing it proclaimed yet. I'd like to tell the Honourable Member that we intend to go live with our e-payments, and that in the course of this year, that law will be proclaimed. But I wonder, where was the Honourable Member's concern? Data Protection Act, Electronic Monitoring Act, DNA Act, Electronic Transactions Act, Madam Speaker. Where was the Honourable Member's concern for the proclamation of laws? Because none of them were proclaimed for 4 and 5 years under the Honourable Member's tenure. So, Madam Speaker, respectfully, I don't seek to take an ounce of advice from the Honourable Member. Madam Speaker, the time frame for proclamation. The fact is, we intend to do an aggressive education campaign. We intend to engage the public sector, including the charitable sector, the non-profit organization sector, to make sure that there is no fear or anxiety in relation to the proclamation of this law, and that is why we have a proclamation clause. Madam Speaker, the Honourable Member for Siparia made an outlandish submission. The Honourable Member sought to pour scorn on the work of this Parliament that we did in the Companies Amendment Bill by saying and reading out the fact that we had dealt with bearer share negotiable instruments, share warrants, etc. Madam Speaker, we did that for Trinidad and Tobago. We banned it in Trinidad and Tobago, and in Section 318 of the Companies Act, we specifically said, with respect to external companies, that we can't ban them in their foreign jurisdictions. So what kind of argument is for Siparia to say we're making a mockery of the law because last week we banned it, and now we're including it in the definition of cash? You have to include it in the definition of cash because cash doesn't exist only as printed in Trinidad and Tobago. You have US currency. you have pound sterling, you have yen, you have real, and similarly you have bearer share negotiable instruments in other parts of the world. So for my learned member for Siparia to make that submission, I feel a deep sense of sorrow at the position that brought us to that conclusion on her part. Madam Speaker, I'd like to remind the population that the FIB...
Your original speaking time is now spent. You're entitled to 15 more minutes to wind up. If you wish it, you may proceed.
Yes, please. Madam Speaker, I'd like to say, not only does the FIB as regulator have an autonomous functionality shrouded in declared secrecy for which there is a breach of the law and criminal sanction if you breach that secrecy, but Madam Speaker, contrary to the representations by the member for Siparia, the FIB does not do the investigative work. The FIU sends it to the FIB, the Financial Investigation Branch of the Trinidad and Tobago Police Service. The police do investigations of SARs and STRs. And for the honourable member to pass off a submission to say the FIU is somehow doing that is to not take concerned effort to look at the Financial Intelligence Unit law, Section 8, Section 9, straight through to Section 18 in its multiple versions included. Madam Speaker, the honourable member asked about the 30-day clause for the approval of the name, and then the honourable member for Oropouche East asked the question about the disapproval of names on the basis of trademarks or geographical indications. I'd like to report that this is lifted almost word for word from the Companies Act. This is the same objection and ability to refuse registration of names because, Madam Speaker, part of the objectives of the Registrar General is to make sure there's no confusion in the marketplace. And you definitely can't do that. If you go back to the Champagne law cases, if you go back to the Maraj and Son cases, if you go to the McDonald's cases, if you go to Cerveceria Polar case, if you look to all of those cases in our local and foreign jurisprudence, you will know that that is trite law. And Siparia ought to know that, Madam Speaker. Madam Speaker, with respect to the forfeiture of property where Siparia sought to pour serious scorn, Madam Speaker. Madam Speaker, the forfeiture provisions which we have provided for are of two types in the same mechanism in a different routing. We take non-profit companies, if I could call them that, registered under Part 5 of the Companies Act. We say that they are to be managed by, ultimately, the official receiver. Why? That's the company's law. It was passed in 1995. Secondly, the official receiver is a public officer. It's his chief state solicitor. Madam Speaker, restored to that position pursuant to the amendment we made last week where we dealt with the lacuna created by the repeal and replace of the Bankruptcy Act by the Bankruptcy and Insolvency Act, Madam Speaker. I don't know where Siparia was for that debate or where the honourable members' attention was on the law in the period 1995 all the way up to 2019, but that has been the law on the books of Trinidad and Tobago for that long, Madam Speaker. Madam Speaker, when the honourable member attempted to treat with that route, that has now been answered. The second route, Madam Speaker. The honourable member for San Fernando East was right. The intellectual underpinning to this law is rooted in the law of trusts. The doctrine of the failure of trust is that the members don't own the property. That's why they need to have approval from the Registrar General prior to incorporation under the Part 5 of the Companies Act, Madam Speaker. That is trite law, Madam Speaker. And there are rules of law to be applied if the trust fails and the beneficiaries can't be found. It's the doctrine of si pre. It is well known since 1601, Madam Speaker. And therefore, I take no comfort in legal advice from Siparia, Madam Speaker, respectfully, because that is trite law in the law of trusts. Every textbook has it. The doctrine of si pre, the thing which is near, Madam Speaker. Madam Speaker, this is why I am a little bit upset in the tone of this debate today and why I'm attempting to address the points which I believe can result in fear and panic, Madam Speaker. Madam Speaker, when we go down to the allegations that we somehow have some complication in the right to appeal, Madam Speaker, the honourable member stood up and told us there are no rules to treat with appeals. So clause 13 of the bill treats with the right to appeal. You don't like the Registrar General's decision under Section 5, Clause 6, and Clause 10, you have the right of appeal to the High Court. We've addressed the fact that that High Court appeal route is the same as the Companies Act. Madam Speaker, does the member not know that if you say you have to be placed in the High Court, you automatically have the right of appeal under the inherent jurisdiction of the court to the Court of Appeal, and under our Constitution, you have the right to appeal to the Privy Council. Just so the honourable members forget that? Just like that? But Madam Speaker, let me tell you the one that really got me today. The method of the Attorney General finding a role in this bill, according to Siparia, is unconstitutional. And here's the reason why. Just because they named it. I would invite the honourable member to read the clauses 21, 22, 23 of the bill. Madam Speaker, the Attorney General is the creature established under the constitutional parameters since 1962, and then importantly in our Republican Constitution. The Attorney General's role under Section 76 of the Constitution is to have the capacity of managing both criminal and civil matters. The capacity of the Attorney General in this law is to apply to a court for a court to consider what it is going to do. It is not the Attorney General who decides willy-nilly as an executive member of a cabinet appointed by a political party. That is not the law. The law is, you could not listen all you want, Carney Central. Madam Speaker, the law in the Constitution is pellucidly clear, but more than that, Madam Speaker, it is replicating Section 22B of the Anti-Terrorism Act. The Attorney General collates the papers, acting for or on behalf of the state, applies to the court to ask the court to determine whether property ought to be forfeited, whether it is to be distributed in the manner that the court suggests, or in some other combination, or whether it is to form bona vacanta, meaning for the benefit of the state, Madam Speaker, because there's no proper owner. So, Madam Speaker, just so, whoops, vaps, Vikey bye, Siparia comes to reinvent the 1976 Constitution to say, hey, pull that Attorney General out. Madam Speaker, I call that an intellectual travesty. I call it a mockery of the law, because, Madam Speaker, this is fundamental ABCs of the law, Madam Speaker. Anybody would know that, particularly somebody who has spent years in the Parliament and has held the office of Attorney General and Prime Minister of this country, Madam Speaker, let alone Leader of the Opposition. I am genuinely disappointed in the intellectual content of that argument. Madam Speaker, that's constitutionality. That is managing the consultative process. That's the hundreds of people involved in that time. That's the years of analysis. But Madam Speaker, I'd like to say, we're not reinventing this wheel. The model that we have chosen is in fact the Caymanian model. We have looked at that model. It has been assessed by the Financial Action Task Force most recently at their last venture, where there was some argument over their ICRG processes inside of the Caribbean Financial Action Task Force, and we know it can pass muster, Madam Speaker. We are not in similar circumstances to the United Kingdom. We do have a written constitution with 3/5 majority issues, 2/3 majority issues, 3/4 majority issues, Madam Speaker. And if we play the dance and game at the invitation of the member for Siparia as we have been invited, Madam Speaker, just throw your hands up in the air, no pass, nothing, you know. Just don't do it. Pandemonium, chaos in our country being blacklisted. See, Madam Speaker, I want to remind this country, the journey into the 4th round mutual evaluation, putting Trinidad and Tobago as the first country to be 4th round mutually evaluated when we had not yet finished our 3rd round mutual evaluation. They say, nah, forget that. Don't worry, we didn't do that. We will go first. We're going brave. Madam Speaker, that was a decision of the member for Siparia, you know. The Prime Minister at the time that took that decision, that authorized by cabinet decision for Trinidad and Tobago to be first in line, was the Honourable Member for Siparia. Siparia knows that we failed the fourth round mutual evaluation in January 2015 when she was Prime Minister, the Honourable Member. January 2015, we failed the fourth round mutual evaluation. The Honourable Member knows, because of the years we've spent in this 11th Republican Parliament, that April is the deadline date. The Honourable Member knows or ought to know, because the Parliament is paying for a whole staff at the Office of the Leader of Opposition, umpteen research staff, half of them sitting in the chamber today and listening. Madam Speaker, you mean to tell me they didn't watch any of the consultations? They didn't see the bill on the websites? They didn't see the Law Association send it out for comment? Oropouche East is a lawyer. St. Augustine is a lawyer. Siparia is a lawyer. Her senators are lawyers. Not one of them received a single email or comment, the honourable members. Not one of them. Cat in bag, surprise, last minute,
Tiffany
external, night. Tiffany night, trade in your sovereignty, push it off till the end of April. Madam Speaker, that's playing fast and loose with the business of the people of the Republic of Trinidad and Tobago. And we will not be caught in that, Madam Speaker. We will not be caught in that. So, Madam Speaker, in conclusion, I reject out of hand the submissions raised by the opposition. They are intellectually shallow, intellectually vapid, intellectually lacking in content. They are designed, in my view, to cause panic amongst regular citizens of this country. I want to tell the citizens of this country, we need to protect our non-profit organization. We need to make sure that we manage regular. All that we are really doing, Madam Speaker, is aggregating the many places where these people are registered. We have the Part 5 of the Companies Act registration. When you're going to open a bank account with a mandate saying Friends of San Fernando West, you have a bank mandate. You have to fill out who the people are. You have to sign the form. You have to have signatures. You're making a disclosure in the bank. Madam Speaker, all that this is doing is putting it in one location. I'll tell you this, for the people who are subjected to the abuses of other jurisdictions, who label them as supporting terrorist financing, etc., this is a get out of jail card. This is an exculpation. This is a I can be saved by the records of my propriety. And nobody needs to have fear on this aspect, Madam Speaker. Any attempt to draw personal piquant and anguish into any form of substance, I welcome personally. Bring a substantive motion. No problems, Madam Speaker. But don't bring it into this law, because this law is proportionate, and I beg to move.
Honourable members, the question is that a bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the Establishment and Maintenance of a Register of Non-Profit Organizations, the Obligations of Non-Profit Organizations, and for related matters, be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
Sorry, Clerk, second.
A bill entitled, An Act to Provide for the Registration of Non-Profit Organizations, the Establishment and Maintenance of a Register of Non-Profit Organizations, the Obligations of Non-Profit Organizations, and for related matters.
Attorney General.
Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the Non-Profit Organizations Bill 2019 be committed to the Committee of the Whole.
Honourable members, the question is that the Non-Profit Organizations Bill 2019 be committed to the Committee of the Whole. All in favour say aye.
Aye.
Any against? The ayes have it. The House will now go into the Committee of the Whole to consider the bill clause by clause. Whip. Are we- So we do part 1, 2, 3, 4, 5. Okay. We doing in parts or clauses 1 to 29 and then
29.
Madam Speaker, I understand that the whip has agreed that we can do all of the clauses together.
Thank you very much. Whip, that's agreed. Yes.
Clauses 1 to 29.
The question is that clauses 1 to 29 stand part of the bill. The question is that clauses 1 to 29 now stand part of the bill. Those in favor say aye.
Aye.
Any against say no. I think the ayes have it. Clauses 1 to 29 now stand part of the bill.
The schedule.
The question is that the schedule stand part of the bill. The question is that the schedule now stand part of the bill. Those in favor say aye.
Aye.
Those against say no.
No.
I think the ayes have it. The schedule now stands part of the bill. Honorable members, the question is that the bill be now reported to the House. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. This committee meeting is now adjourned. The House will resume. Attorney General.
Madam Speaker, I wish to report that the Non-Profit Organization Bill 2019 was considered in Committee of the Whole and approved without amendments. I now beg to move that the House agree with the committee's report.
Honorable members, the question is that this House agree with the committee's report on the Non-Profit Organization Bill 2019. All in favor say aye. Aye. Any against? No. The ayes have it. Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the establishment and maintenance of a register of non-profit organizations, the obligations of non-profit organizations, and for related matters be forthwith read a third time and passed.
Honorable members, the question is that a bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the establishment and maintenance of a register of non-profit organizations, the obligations of non-profit organizations, and for related matters be forthwith read a third time and passed. All in favor say aye. Aye. Any against? No.
Feels going good.
Mr. DLC.
Yes.
Mr. Al-Rawi.
Aye.
Mr. Imbert.
Of course, yes.
Mr. Young.
Yes.
Mr. Mitchell.
Yes.
Ms. Cujo.
Yes.
Mr. Garcia.
Yes.
Mr. Ford.
Yes.
Mrs. Webster Roy.
Yes.
Dr. Gadsby Dolly.
Yes.
Dr. Francis.
Yes.
Mrs. Jennings Smith.
Yes.
Miss Oliver.
Yes.
Mr. Leons.
Yes.
Mr. Coffey.
Yes.
Mr. Lee,
No.
Mr. Charles,
No.
Dr. Rambachan,
No.
Mr. Karen,
No.
Dr. Tewarie,
No.
Dr. Moonilal,
No.
Mrs. Nawalu Hussein,
No.
Draconian piece of legislation.
Mr. Indar Singh,
No. Punitive.
Mr. Bhoendradatt,
No.
Dr. Budo,
No.
Ms. Ramdial,
No.
Madam Speaker, the results of the division is as follows. 15 members voting for, 0 against, and 11 abstentions.
No. Not 11 against?
11 against. It's 11 no's and 0 abstentions.
Honorable members, on a division of votes, 15 for, 11 against, no abstentions. The ayes have it.
A bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the Establishment and Maintenance of a Register of Non-Profit Organizations, the Obligations of Non-Profit Organizations, and for related matters.
Leader of the House.
Madam Speaker, I beg to move that this House do now adjourn to Friday, 5th April, next Friday, 2019 at 1:30 p.m. At that time, the government proposes to debate an act to provide for the establishment of the Civil Asset Recovery and Management Agency. Thank you very much, Madam Speaker.
Honorable members, as we all know, Spiritual Shouter Baptist Liberation Day will be celebrated on Saturday. And therefore, before I put the question on the adjournment of the House, I will now invite members to express their greetings. Member for...
Madam Speaker, good evening. Members of the House on both sides, good evening. It's my pleasure to stand to bring greetings on behalf of the government for Spiritual Baptist Liberation Day. Madam Speaker, we've had a very spirited debate this afternoon in which some strong language was heard. I heard the word communist, I heard the word authoritarian, I heard the word repression. And at the end of the day, even though in the context of the debate we might feel strongly about what we say, the words are hyperbolic and a bit exaggerated. But I could take you back, Madam Speaker, to 1917, when words like that, exclude communists, would have had some fundamental meaning in terms of this society. Madam Speaker, in 1917, a colonial government, driven by a distaste and a fear for any kind of cultural or political expression that was considered to be dangerous to its survival, to its control of the society, opted to prohibit one particular cultural group, one particular religious group from worshiping in the manner that they chose. That group was, of course, the Spiritual Shouter Baptists. Madam Speaker, if one looked at the order that prohibited the expression of that language, of that religion, the reasons given for banning this language, for banning that religion, were spurious at best, absurd at worst. The ringing of bells, the loud singing and chanting, which was supposed to have discomforted members of the community, were not the actual reasons why religion was banned. It was because the Spiritual Shouter Baptist religion was seen as a very Afrocentric expression of faith by a government that repudiated the right of that group to express itself and to worship in a manner in which it saw fit. So the religion was banned. The idea was to drive it underground. The idea was to exterminate it. The first succeeded. The religion went underground. Madam Speaker, if you've come to Moruga, which is the homeland of the religious home of the Shouter Baptist faith, and you try to find a church on the main road, it is a very difficult thing to do. Any spiritual Baptist church that is on the main road is a new construction. The traditional churches, those would have existed from back when. You have to go some miles up into a road. You have to go somewhere behind a river. You have to go off the beaten path to find the churches, because that was the only place that one could find to worship. And worse than that, the police were empowered by law to arrest you, to take you before court, to use brutality, to suppress you, to control you, to beat you. Even if it meant that they didn't need a warrant to come to your home, they could come to your home and take you away for something we take for granted today, which is the right to practice your religion as you see fit. And Madam Speaker, this went on until 1951, until this order was repealed. It did not destroy the Baptist faith. It did not destroy the Baptists. In fact, more than anything, it made the Baptist faith stronger. It made the resolve of the Baptist adherents more powerful, and they survived. Madam Speaker, today in Trinidad and Tobago, we have a very strong, very resilient, very patriotic, very determined spiritual Baptist faith. In many ways, their struggle is emblematic of our larger struggle as a nation to move beyond the confines of our history, to move beyond our colonial past, and to become all that we can be as a nation. It is right that we celebrate them, that we acknowledge their struggle, that we acknowledge the historical wrong that was done to them, and that today we venerate them. As a person who is the son of a spiritual Baptist mother who has died, I understand a bit of the faith, and I know the kind of strong individuals that were bred by this religion. So it is my honor and my pleasure on behalf of this side of the Parliament to bring greetings to this religion, to know that we as a state now do not take for granted that right enshrined in our Constitution that every single person has the right to worship as they see fit, to know that regardless of which side stands as government, that we will defend that right as part of a democratic reality, and that we celebrate with them their liberation because it is our liberation. Madam Speaker, I thank you.
Madam Speaker, tomorrow commemorates the repeal on 30th March 1951 of the 1917 Shouter Prohibition Ordinance that prohibited the activities of the Shouter or spiritual Baptist faith. According to Section 2.1 of the ordinance, and I quote, "A Shouter's meeting means a meeting or gathering of two or more persons, whether indoors or in the open air, at which the customs and practices of the body known as Shouters are indulged in. The decision of any magistrate in any case brought under this ordinance as to whether the customs and practices are those of the Shouters shall be final, whether the persons indulging in such customs or practices call themselves Shouters or by any other name." Section 7.1 states, "It shall be lawful for any party of members of the police force, of whom one shall be a gazetted officer, without warrant, to enter at any time of the day or night, any house, estate, land, or place in or on which such gazetted police officer may have grounds to believe or suspect that a Shouters meeting is being held, or where he may have good grounds to believe or suspect that any person or persons is or are being kept for the purpose of initiation into the ceremonies of the Shouters." And Section 8 states, and I quote, "Any person guilty of an offense under this ordinance shall be liable on summary conviction to a fine of $240. That is in excess of $70,000 today. Now, while most European religions received active support and others were merely tolerated, Spiritual Baptists were the only ones hounded down and fined enormous sums for practicing their faith in our country. In the case of the London Baptists, in which tradition I grew up, the Baptist Missionary Society in England provided financial and other support to build churches, schools, and colleges, such as Cowan Hamilton Secondary School. Spiritual Baptists got nothing. Selwyn Kojo, in his recent and well-researched book, The Slave Master of Trinidad, writes about William Harding Burnley, the richest planter in the colony, until he died in 1850, leaving an estate valued at over £260,000 then. He was formerly a most active member of the Council of Government, as the Legislative Council was named at the time, and was a benefactor of the Anglican Church. Burnley donated, for example, the lands upon which the present St. Mary's Anglican Church in Tacarigua was built. The Catholic Church received active support from the powerful French settlers brought into the country after the settler population in 1783. No such luck for spiritual Baptists. Today, there is a significant underrepresentation of spiritual Baptists in Parliament and in the hallowed halls of governance. Spiritual Baptists are not among the movers and shakers of our country. They have no colleges or institutions of tertiary education. They have no recognized and accredited institution for training their bishops and archbishops in accepted doctrines of the faith and for honing their leadership skills. As we celebrate this year's anniversary, we must collectively give thought to righting the enduring legacy of past injustices to this faith. Our university and our scholars must examine the enduring legacies of marginalization and seek ways of righting this historic wrong. Madam Speaker, Mr. Pandey and the People's Partnership under the leadership of the members for Separia did their part by building the first spiritual Baptist primary school and an early childhood center in Maloney, and also the grant of a national holiday. The UNC joins with the national community in wishing our spiritual Baptist fellow citizens best wishes as we celebrate this important and historic milestone in our development. Thank you.
Honorable members, I also extend my greetings to the Spiritual Shouter Baptist community as they prepare to celebrate Spiritual Shouter Baptist Liberation Day tomorrow, Saturday, March 30th. This day was hard fought and won in spite of many challenges from mainstream society, and is representative of the rich heritage and history of our Twin Island Republic. Honorable members may recall that Trinidad and Tobago is the only country in the world which celebrates this day by way of a public holiday. As we join with the national community in commemorating this special day of religious liberation, let us also appreciate the significance of this unique fusion of elements of Christian doctrine and the rhythms of the African, that is, Shouter Baptist religion. On this day, we reflect on the trials endured by the Shouter Baptist faith to gain the right to freely express the vibrancy and dynamism of their religion. But let us not diminish its demonstration of the value of the fusion of differences in producing a whole new, beneficial, resilient, and exemplary model. Further, it is in this context of freedom that liberty should not be taken for granted. Indeed, it serves as a reminder to all members in our role as legislators of the importance of protecting the fundamental rights and freedoms of all citizens enshrined in the Constitution. I therefore take this opportunity on behalf of the Parliament of the Republic of Trinidad and Tobago and on behalf of my family to wish you and all of Trinidad and Tobago a joyous and holy Spiritual Shouter Baptist Liberation Day. Honorable members, the question is that this House do now adjourn. All in favor say aye. Aye. Any against? The ayes have it. In accordance with Standing Orders 11 and 12.1, this House now stands adjourned to Friday, 5th April 2019 at 1:30 p.m.